we can call the next case, which is Edward Havill versus John A. Baldwin, while Judge Evander and Judge Orfinger change seats. All right, I think we're ready to begin. Either Mr. Wood or Ms. Stewart. Ms. Stewart.
May it please the Court, I'm B. Jordan Stewart of the firm of Wood and Stewart, PA. With me is my partner, Gaylord A. Wood. We are counsel for the appellant, Edward Havill, as Lake County property appraiser. In 1972, the legislature enacted Chapter 72-181 Laws of Florida, which revolutionized the law concerning the agricultural classification. Prior to that time, the old law, enacted in 1959, placed the emphasis solely on the use of the property. With the development and the growth of development in Florida, the legislature was made aware that something had to be done to protect and enhance agricultural lands. 72-181 was the result, which was then codified as Section 193-461-3B. That statute stands today. The part of that statute that's relevant to this case, is 461-4C. That's what we call the 3 times value law.
Other than the high price that was paid for the land, are there any other factors in the statute, described in the statute, which apply to this case?
Yes, Your Honor, I think that's a very broad question. What happened about 10 months after the enactment and the codification of the statute was the DOR was requested by the legislature to put forth a administrative rule.
Yeah, but we're not bound by that rule, are we?
I believe it carries the force of law, yes, sir.
That's a series of rules that are given to assessors for their use in evaluating. But they've never been adopted by the legislature, nor have they ever been recognized, I don't think, by any appellate court in the state, at least not that I recall.
It's my understanding that the administrative code carries the force of law and must be seen as such. I think Autumn versus Foremost Dairies is the case that deals with that, if I'm not mistaken.
Well, my original question was,
yes, sir.
Other than the high price that was paid for this land, are there any other statutory, not administrative, but statutory factors that are called into play by this case?
Yes, Your Honor, there are. There are the 7 factors in Section 193-161. Which of those compel a determination that this was non-ag land? They have to be viewed in the light of Section 193-461-4C. That statute tells us that when land is sold for more than 3 times its agricultural value, that the property appraiser, in order to grant the classification, must find special circumstances.
Well, didn't the Florida Supreme Court say that in considering those special circumstances, you're to go back to the factors in the other 6 factors listed in the statute?
Yes, sir, certainly. But the factors cannot, as a matter of logic, be viewed in exactly the same way.
Well, let me ask you this. Would these be special circumstances that would the trial judge could consider in overcoming the presumption, 1, that the owner had a contract with another individual to maintain the property as an orange grove and harvest fruit? Would that be a special circumstance?
No, Your Honor, I don't think it would be. That merely takes us back to what was there when this property was effectively another property.
Pretty much, your argument, as I understand it, really is if they pay too much for the land, it can't be agricultural no matter how they use it. Because
that is absolutely not the case.
that sounds like it. You want us, because the trial court in this case went through every single factor, considered everything, and made a determination of fact, and the only fact that goes your way, as far as I can see, is the purchase price paid. Every other fact, it looks like went in favor of the landowner, because it certainly looks like he's still farming oranges on that land. So it looks to me like your argument is if you pay too much, the factors don't matter, the presumption's mandatory, that's it.
Your Honor, the special circumstances certainly could have been present. In fact, in Strong
What
versus...
in addition to the fact that they're still using this for agricultural purposes, all the facts that the ALJ found here, what in addition would you think they would have to show in order to show special circumstances to overcome the presumption?
I think they would have to show that they had to pay a special price because they needed the land to continue their agricultural use. That I think an example that might be appropriate to this case would be, one of the facts in this case was that there was tristeza in some of the trees, and that was the reason that they were not replaced. This is not in the briefs, but a special circumstance might be, well, we bought the land across the street because we can't replace the trees that we have, and we need to keep up the same level of production that we have now. And we had to pay a lot for that land because that's what it's worth now. We want to keep our agriculture. What the Department of Revenue was trying to say in the administrative rule is, yes, look to bona fide agriculture and use the 7 criteria to look for bona fide agriculture. But you cannot merely look at what might have been there before and say, well, that was bona fide before and it's bona fide now. This is an entirely
But the property's use hasn't changed. If it was bona fide...
it had, Your Honor.
Well, no, they bought a parcel of it, but it's still being used the same way as it did before the purchase, right?
That 3 acres was being used in...
He hasn't sought a change of zoning. He hasn't advertised the property for sale. He hasn't requested annexation anywhere. All he's doing is growing oranges.
Prior to the purchase, you had a 25-acre parcel of property, which included this 3-acre parcel, which was used for specialty oranges, package oranges to go out intact, and the other 22 approximate acres went as juice fruit. Now, there's no evidence in there as to what the money maker was prior to that use.
How is the 3-acre parcel being used differently after the property owner bought it than it was before he bought it? How is the 3-acre parcel being used differently?
They paid an awful lot more for it.
Other than that, how is it being used?
That 3-acre parcel, if you wish to consider that the same property that it was when it was a 25-acre parcel, and they didn't carry an investment...
The 3-acre parcel was never a 25-acre parcel. I'm asking about the 3 acres. How was that 3 acres used differently before the purchase by Mr. Baldwin?
If you limit to physical use, Your Honor, you're quite correct.
If the 3 acres before the purchase was used for bona fide agricultural purposes, and its use hasn't changed at all, then why wouldn't it be for bona fide agricultural purposes after the purchase?
Because the legislature has told us that where a property is purchased for more than 3 times, and in this case it's 10 times the agricultural value, that it's not the same. And you just simply, it's not reasonable to ignore that statute. In fact, I think that Markham versus Nationwide Development got it right. They measured the bona fides of the use under the 3 times value law by recognizing the cost of the land as one of the factors. And it indeed is one of the factors that is to be considered in the 7 criteria. Now we have, as of the 3 times value law, we now have something that not only tells us to recognize the cost of the land, but tells us when to recognize it and under what circumstances to recognize it. And then we have if you want to call it an advisory, I still maintain that it carries the force of law. We have the elaboration in the administrative code that gives us a very clear and definitive idea of what those special circumstances should be. The trial court here has told us that none of those special circumstances existed.
What did the Supreme Court say was the guidepost in classifying the land? The purchase price or its actual use?
Actual use is the guidepost, but actual use is to be measured by the 7 criteria. And some of those are not mere use criteria. If we go back to actual use defined as are there oranges being picked, and are they going to the producer or the grower, we're back to 1959. We're back to the old law. That's not where the legislature intended us to be. In 1972, the legislature told us the use must be bona fide. They told us it must be...
Are you equating bona fide with financially viable? In other words, are you saying that in order for there to be a bona fide agricultural use, it has to be one that makes sense? In other words, you have to be able to make money from the agricultural use.
I think that...
Or you have to have some reason why in the broader context with other property it makes financial or business sense to use this for agricultural purposes, even though it might not look like it makes financial sense based on the purchase price. Is that your argument?
Judge Lawson, I think that would be a very good way of saying it. We've heard so much about reasonable expectation of making a profit. Well, I think we ought to take profit out of it. Agriculture in Florida is rarely profitable anymore, and most small farmers have to go out and do day jobs in order to keep their land. We don't require that a farm make a profit. The case law has told us that. The courts have reiterated it over and over. But where we have land banking, we have to look to what is reasonable, not whether or not you're getting a net check at the end of the term, but whether or not it's reasonable to assume that the dollars paid for that property could possibly, under the circumstances, and when I say circumstances, I mean the 7 criteria, constitute bona fide agriculture. I'll even leave out the commercial requirement for the benefit of not confusing things. But that's where we are making the mistake in going, is to say, let's go back to just the use of the property. No, we cannot look to the future. We cannot determine what Mr. Baldwin may or may not do with his property. We cannot say, you must make a profit. But we can say, we want to keep agriculture in Florida. We want to do everything we can to benefit the agriculturalist. We can do so by looking reasonably to the cost that somebody pays for the land in the absence of some agricultural basis for that cost.
Right. Are you saying if a person buys a piece of property and pays more than its use as agricultural property with the intent 10 years later to sell the property to profit, but during those 10 years to use it for agricultural purposes, are you suggesting that the legislative intent was for that person to be taxed at the higher rate for those 10 years?
Not completely. I think that's stating it a bit too broadly, if I might.
Well, how would that differ from this case if the intent of Mr. Baldwin was to sell it 10 years later and to, he paid more than it was worth as agricultural property, but maybe not worth more than it would be down the road. So what if he wants to use it for an orange grower for 10 years? Well, are you suggesting that he should pay the full freight tax-wise for those 10 years, even though he's using it for an orange grove during that time period?
I would suggest that, first, we have to look to special circumstances. Now, perhaps a special circumstance might be, I'm a very wealthy man and I truly want to be a farmer. I go out and I pay more than 3 times value for acreage. I put an agricultural use on it, and I see to it that either I or somebody else uses it to its maximum to put food and fiber into the industry. Perhaps that's a different circumstance than this.
Well, I'm all in favor of fiber, but let me just ask where the word special circumstance shows up under the definition of a bona fide agricultural purpose. Because I'm reading the statute and I don't see it.
That would be in section 193.461 4C.
4C, right? You know what? Give it to me again. 191 what?
I'm sorry.
4614C.
4C. I've got a very sloppy copy, I'm sorry.
Give me the statute reference again. I've lost it. I'm on 191.
193. 461.
461. Okay.
It reads, sale of land for a purchase price which is 3 or more times the agricultural assessment placed on the land shall create a presumption that such land is not used primarily for bona fide agricultural purposes. Upon a showing of special circumstances by the landowner demonstrating that the land is to be continued in bona fide agriculture, this presumption may be rebutted.
But didn't the Supreme Court say that in considering what special circumstances meant, you had to go back to the statutory factors, and the failure to do so might render the statute unconstitutional. And that's why you went back to the factors.
I agree.
All right, and every factor, other than the purchase price, according to the trial judge, favored the property owner. So,
I would not agree. I think that, first of all...
well, Judge Lawson asked you, to give one factor that didn't, and what factor wouldn't favor other than the purchase price?
Whether or not the...
You got 4 minutes left.
Thank you. May I reserve 3 of them?
Sure.
Whether or not the use is continuous. We maintain that a 3-acre parcel of agricultural land, particularly oranges, is not a 25-acre parcel of agricultural land. The change in ownership, the size of the land, the use as it, the care and use.
I'm having a hard time with that concept, the incredible shrinking land. 3 acres is 3 acres. If they use 3 acres for orange production, they're still using those 3 acres for orange production. The fact that they're also maybe using 22 additional acres for production doesn't change the use of this land.
Economies of scale, Your Honor. We must talk about the economic merchantability of the product as one of those factors.
Well, but you told us that nobody makes a profit being a farmer anymore. So no matter what you do, you're not going to end up...
It's not a matter of profit. It's a reasonable expectation of making a profit.
Let me ask you, would this, under your definition, would this be a special circumstance? Suppose I say, I'm interested in this parcel of property because I think in 20 years it might be really valuable, and I can afford to hold it for 20 years if I can continue to use it as an orange grove, because it's cheaper to do that, in part because of the tax benefit of using it as an orange grove. But if I can't continue to use it as for orange production, I can't afford to do it. Why wouldn't that be a special circumstance? I'm buying this property because I want to develop it 20 years from now, and I can afford to do that as long as I continue to use it for orange production. So it works for me financially that way. Is that a special circumstance?
I think we have to look to the 7 factors and see whether under...
I'm doing everything that this guy's doing. I'm continuous. It's continuous use, number 2. The size of the property hadn't changed, and the relationship of the agricultural use. I'm not going to, develop half of it and only use. I'm going to continue to use all of it for that purpose. I'm going to continue to adequately care for the land and make it as commercially viable as possible. All the other factors. I'm going to continue to operate an orange grove because that makes economic sense to do that for 20 years. If I can sell it later for more money, is that a special circumstance?
Not under the facts of this case, sir, because we have 3 acres of grove without absent spaces all over it, with no plans to replace the trees. Yes, it's being cared for, and yes, it's being done by the same person who did it prior to the transfer, but it is not being done in such a way that it shows a maximization of the use of the land.
You're down
It's
to 1
not.
minute if you want to hold that.
Thank you, Your Honor.
Good morning. May it please the Court, my name is Chris Carlisle. I'm here this morning on behalf of the appellee, John Baldwin. This case contains a final judgment that is very lengthy and very detailed based on competent substantial evidence that came to the conclusion that on January 1st, 2005, the property was an active grove, producing fresh fruit for market. The evidence in this case was overwhelming. There is virtually nothing that could have been done beyond what was done in this case to maintain a bona fide agricultural use of this property on the date in question.
Well, they could have bought new trees.
I'm sorry?
They could have bought new trees to replace the diseased ones.
There was a factual determination made by the trial court that there was evidence that that was not a good idea. They relied on their experts to do that. And so, respectfully, the trial court found that they were maintaining it appropriately based on the expert advice they were given. All of these factors, all of this information about what they were doing, according to the property appraiser, is not enough. It's not enough. What was happening here, the special circumstances we talked about, he met beforehand with the people that had maintained it, and they agreed to do it in the future. They, in fact, did maintain it during the period of time that he owned it. They watered, they herbicided, they trimmed, they did everything they had to do. They harvested the crop. There was testimony they made a profit from the crop. And despite all that, the property appraiser says this was not enough. This is not an agricultural use. In order to buy that, you have to ignore the statute, you have to ignore a 30-year-old precedent from the Florida Supreme Court dealing with this, and you have to ignore your own precedents. We need to look, first of all, very quickly at the statute which we just read, and Judge Monaco was talking about. Special circumstances demonstrating that the land is to be continued in bona fide agriculture. What are those special circumstances? Well, the Strawn case says we look at the factors in the statute to determine if there is a continuation of the bona fide agriculture. The Strawn case from 76, the Florida Supreme Court, couldn't be more clear. It talks over and over and over in that case about what do we look at. Evidence tending to confirm the agricultural nature of the land, i.e. special circumstances, should conform with the 6 factors, as Judge Evander continued to point out. When the 3 times value is paid, a red flag goes up. The property owner must come forward with evidence of special circumstances within the framework of 461(3)(b), which is now changed, to establish that the land continues to be used for, quote, bona fide agricultural purposes. These factors are the most significant. That's been the law of the state for over 30 years. The Florida Supreme Court couldn't have been more clear. That's exactly what the trial court in this case did, is look at those factors, and as this court has mentioned over and over here, all of them weighed in favor of the property owner and of the determination that was made here. This court also should be aware and look to a couple previous decisions, including the Gomble case from 1980. Very similar to this case. We have a citrus grove for 12 years, classified as agricultural. Come in, they harvest the crop, and in that case, just as in here, there was an argument made I think it's important to be aware of. The Department of Revenue there argued that not just a continuation of the agricultural use, that's not enough. There must be something, quote, unique was the language used in Gomble. And again, there was a discussion in that case of the expectation of a reasonable profit. The very same arguments here. No, continued use is not enough. You have to do something unique. There has to be something more. Special circumstances doesn't just mean the factors that the Supreme Court told us they did. It means something beyond that. That was rejected by this court in Gomble 26 years ago. The next year, the Zagas case comes out and concludes the following statement from this court. The presumption may be overcome by a showing of a continuation of agricultural use. Why is that? Use is the guidepost. The Supreme Court tells us that. What do we look to? We look to the factors. Exactly what the court did here. There's no mention of the standard of review in the initial brief in this case, but the standard of review is competent and substantial evidence. Is there competent and substantial evidence in this record? Absolutely. I think it's also interesting to note and worth considering in response to some of the questions. There was a statement made that the intent is to keep agriculture in Florida. But the irony of this case is to do what the property appraiser is suggesting is to have the opposite effect. Meaning, again, the example was given, what if I want to buy an orange grove that my kids can play in and maintain it as an orange grove? I'm now going to be forced by the property appraiser to not be able to do that and develop it sooner because I'm not going to get the agricultural benefit the tax benefit of the agricultural classification. So if we're going to classify property in that way, we're going to remove any incentive from a property owner who buys it for that to maintain it as an agricultural use, and we're going to force them into development sooner rather than later. Finally, again, I'm in response to some of Judge Lawson's statements. I think if you review this case and you review the transcript of it, it is absolutely clear that the law was misapplied by the property appraiser in this case. And the position seems to be, number one, if it's 3 times, sorry, you're out of luck. Number 2, well, maybe we'll look at the administrative code factors, which in the code itself says they are factors to be considered, but they're not limited to those factors. And again, that's the administrative code, the language itself. And there is no consideration given for the statutory factors that the Supreme Court says must be considered in this case. If this Court is inclined to write on this case, I think a clarification of the existing law, which has been clear for 30 years, might be in order, because it seems that there is a misapplication of the law in this case and perhaps in other cases throughout Florida at this time.
If the law's been clear for 30 years, what needs to be clarified?
Again, I don't know if it needs to be clarified, but another reiteration, because this Court hasn't for the last 26 years made it clear, and evidently certain governmental agencies are not clear or not applying it in the way that the Supreme Court told us it should be applied. But I agree with you. No further questions. I thank you very much.
Thank you, counsel. All right. Appellant, you have 56 seconds.
I would like to clarify a couple of things. What the courts basically have said regarding when you can't deny the ag is that where you deny on solely one basis, if you deny solely because of the purchase price, as in Gimbel, and not look back to the 7 factors, the other factors at all, you go down. In Sagas, size was the sole criterion, and nothing else was looked at. That's what the courts have told us. They have not told us to mindlessly go back to what was there before in the face of a statute that tells us we must look for more. I'd like to briefly go over where I believe the court erred in including the subject property as part of a prior larger grove. What we have now is 3 acres. We had 20. Determined that the prior use was continuous.
Counsel, I'm going to give you another minute to wrap this up, but you're
Thank
already
you
out of
very
time.
much, Your Honor. Failing to require special circumstances in its analysis, it specifically did not. It said there was no evidence of the circumstances that are listed in the administrative rule and stated no others. Applying the 7 factors as if there had been no 3 times value rule or a transfer. Applying the use standard applicable to a 20-acre farm to a 3-acre grove, based on the percent of damaged trees and the percent of viable crop, none of which was given any emphasis. Very briefly, Markham versus Nationwide Development, which has not been disapproved, Markham versus Gianolio disapproved it on other grounds, states the requirement very well. Measuring the bona fides under the 3 times value rule by recognizing the cost of the land as one of the 7 factors.
Let me just ask one thing.
Okay.
On that rule as far as the application. I mean, that's talking about where you buy property to get to agricultural land, whether by drainage or road or whatever. I don't even see how that would apply in this case. He didn't buy this land to get access by road or drainage to a larger area. He bought this land and used it for farm areas. So I don't even understand how the rule is applicable.
He bought a piece of land, paid more than 3 times the agricultural value for it, and left that piece, part of a larger grove, in essentially the same or worse condition than he found it.
Thank you.
Thank you.
We are going